Court calls case People versus Brandon Hampton.
Public Defender Fellow Nicholas Bukovich on behalf of Mr. Hampton.
Right out of the gate, this hearing starts with Brandon Hampton standing before Judge Simpson, and the issue sounds simple. His attorney wants more time to review media evidence, but courtroom viewers already know simple can turn sideways fast. This is the kind of moment where procedure matters more than emotion. The defense is asking for an adjournment because they need to actually see what evidence the prosecution has before moving forward. That is not delay for fun. That is basic due process. But Hampton immediately seems to misunderstand what is happening. He thinks asking for more time somehow means backing away from forcing the prosecution to prove its case, and that confusion creates the first spark. Judge Simpson now has to do two things at once: keep the hearing moving and explain that reviewing evidence is not surrendering, it is preparation. Watch closely, because this case turns from routine scheduling into a courtroom control issue very quickly.
Your name, sir?
Brett Hampton.
Thank you. You're requesting an adjournment?
Yes, I am requesting an adjournment to obtain media to be able to view it with my client. I believe I accidentally sent it to a request to the wrong prosecutor at this time. So
I'll decline that and have the people actually prove that I'm guilty of anything.
Pardon, sir? What?
I'd like to decline that and have the people prove that I'm guilty of something.
Decline what?
Mr. Hampton.
What are you declining?
I want the people to have to do what they have to do today. Their premonition trial.
Well, you want me to try to...
We can set that out for that. However, we want to...
But we don't need to do anything today. They need to prove that I'm guilty of something.
Mr. Hampton, Mr. Hampton, this is not...
Mr. Hampton, I understand the burden. What your counsel's doing is he's making sure to look at everything that the people would be looking at.
They're going to be giving me the video they have so I can see what they have.
Mm-hmm. Yeah, and I want to know what they have now. Let's see.
Well, that won't happen today.
It will not happen. We need to set up a preliminary exam another day once we have the video and know what they have.
November 7th, 2024, 9 a.m. Bond continued. Thank you. Wow. You know what? I don't think you want to do that, sir. You hear me?
I apologize, Your Honor.
He better take himself out of here because otherwise he's going. You're gonna go. Keep it up.
I apologize, Your Honor.
Why? Did you start it?
And there it is. The hearing has already slipped from legal procedure into courtroom discipline. Hampton's attorney was trying to help him. Judge Simpson was explaining the process, and instead of letting the adjournment protect his defense, Hampton appears to push back in a way that forces the judge to shut it down. The irony here is huge. He wants the prosecution to prove the case, but the adjournment is exactly what helps his lawyer prepare for that fight. Instead, the tension spills over, and Judge Simpson's warning makes it clear that attitude in court has consequences. This is one of those courtroom moments where viewers have to ask, was Hampton frustrated because he did not understand the process, or was he simply unwilling to trust the one person appointed to defend him? Drop your take in the comments, because this moment says a lot about how quickly misunderstanding can become self-sabotage.
Okay, let's see who's next.
What do you want to say? I'm Bernstein with and on behalf of Mr. Gregory.
Good morning, Mr. Gregory.
All right.
And I know there's a bond violation that we probably have to address first before the next stage, if the court would like to do that.
Yes, go ahead.
So it's for not making it to community corrections as referred. Your Honor, Mr. Gregory's had a very rough time once he got out of jail. He's an epileptic and he didn't have his seizure medication while in there, and his brain's been a little fried. He enlisted his mom's help when he got out after community corrections gave him a call, and she called a couple of times but wasn't able to get through. So it's just been very.
Who called?
His mom called.
Called where? Community corrections?
Yes, after they called.
When did that take place?
The day that he told her. And I talked to her this morning and last night. She said she left several messages. And
When? Because it's not even reported on here. Ms. Mahal.
The day that,
Go ahead.
the day that he spoke with Community Corrections, Your Honor. That's what she told me. She called several times and tried to make contact.
That's not what this at all says.
Well, she left voicemails, Your Honor. I don't expect them to write down voicemails, but she was trying to help him. Hold on. When he got out of jail, he did not have his seizure medications. It was still at the jail. He's been having a very difficult time. He went to the hospital for almost a day because he was seizing. It's just been very difficult for him to get his affairs back on his feet after release, Your Honor. He tried to have his mom's help. He didn't quite get there. They went to Community Corrections this morning to try to rectify it. When I informed them about it last night, they said that he needed a new referral. I talked to him about what this all entails. He has absolutely no problems going to Community Corrections.
Go ahead.
Now the courtroom shifts to Mr. Gregory's bond violation, and this one has a very different tone. His attorney is not denying the missed community corrections appointment. Instead, he is trying to explain it through medical hardship. Epilepsies, lack of seizure medication, hospital issues, confusion after release, and help from his mother. That matters because bond violations are not just about whether something happened. They are also about whether the judge believes the explanation. Judge Simpson is listening, but he is also comparing every claim against the written report. That is why his go-ahead is not casual. It is controlled skepticism. The defense is trying to build sympathy, but the report says Gregory scheduled an appointment and failed to appear. This is where courtroom credibility becomes everything. A medical issue may explain confusion, but it does not automatically erase a court-ordered obligation.
I'm listening to you, but I'm also looking at what's stated here. He said he needed to talk to his mother regarding the appointment, and we haven't heard from him.
Yes, sir. He did not go back to Community Corrections after that phone call. He tried to have his.
Why not?
I didn't understand where it was at or how to do it. I'm not gonna lie.
He scheduled an appointment. He telephoned them and scheduled his intake for October 17th.
Yes.
He failed to appear for that appointment. Where was he?
He was at home, Your Honor, with his mom. Like I said, he was having a very difficult time. He had spent time in the hospital after getting out of jail. He didn't have his patients because he can't re-up them after he leaves. And so he's been having seizures on and off. His brain's been fried. I know people with epilepsy, it's a thing where your brain gets fried to where you can't think straight. That's just the condition he's been in for the last.
They then called him, and he stated he was suing as he was not given medication while jailed and could have had a seizure.
Mhm.
Then he stated, according to this, he needed to talk to his mother regarding the appointment.
Right, Your Honor. And that's my
And
thing.
then we haven't heard from him.
And he tells me, and I've spoken with his mom, that he told his mom that she was trying to help him through the issue. She
What
called
do you
Community
want?
Corrections.
There, is that his mother?
Yes, Your Honor.
The one waving at me?
I do believe so.
What is your name? What do you want to tell me?
Just on the, he's not really, it wasn't, his father called and scheduled, whatever. I didn't know anything about him having to report to me, even though I was finding him out. Once I did hear from him stating that he was supposed to be with Community Corrections, I called several times and left messages just to come back to see exactly what was going on, because I didn't know. So with the lawyer yesterday about 3 p.m., he told me about the violation and what needed to go on. I let him know that I would take action of Community Corrections to get scheduled and get what needs to happen. He didn't tell me that we needed a new referral. When we went this morning, they didn't come.
He should have gone over there the first time.
Judge Simpson cuts straight to the core problem. Whatever confusion existed later, Gregory was supposed to go to Community Corrections the first time. That line is important because the court is separating sympathy from responsibility. The mother says she did not know everything. The defense says Gregory had medical struggles, and Gregory says he did not understand what to do. But from the court's point of view, the bond condition was still active. Community corrections was not optional. This is the kind of hearing where everyone's explanation might be emotionally understandable, but legally weak. Judge Simpson is basically saying, I hear the hardship, but I still do not hear a clean reason why the court's instruction was not followed. And that is a dangerous place for a defendant to be, because once a judge stops believing the explanation, the next decision can become much harsher very quickly.
That's correct.
I don't even hear a reason why he did.
We just didn't know what was
I
going
didn't
on.
know what to do.
You called them.
That wasn't me. I don't know nobody. I don't know what to do.
And as far as the seizure medication, we still weren't able to get that today, so he still does not.
The report I have indicated he called over and scheduled his intake for October 17th.
That was,
I didn't call nobody.
that was his father.
And your father didn't let you know that it was scheduled for that day?
Nobody did, sir. Nobody. I didn't call no one.
What are we doing on this case? I don't believe any of this, but go ahead.
Well, what I do, I guess, depends on I was begging for a second chance for him to get to community corrections. He can go there right now. I have good contact with
What
him.
are we doing with the case is my question.
I have a green form to ask for an adjournment, Your Honor.
Probable cause conference, October 31st, 2024, 9 a.m. At this time, I'll let his bond continue. I'm signing a referral right now. You need to go over, once you leave here, you need to get over to community corrections and do the intake. Am I clear?
Okay.
Thank you. So, people versus Ahmet, is it Enright?
Yeah.
And
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Aaron Wright. Mr. Aaron Wright, please state your name for the record.
Good morning. I just wish to mention for the record that earlier this month, I mailed 2 letters, one to the prosecution and one to the attention of the judge. And my name is Amit Ehrenreich.
Now we enter the Amit Aaron matter, and the first thing he wants on the record is not the charge, not the hearing date, but his name and the letters he mailed. That may sound minor, but in court, the record matters. A defendant wants the court to acknowledge what was sent, what was received, and whether the judge has seen it. But the bigger issue here is competency. His lawyer says the case has been out for a competency report, and neither side appears to have received it. That means Judge Simpson cannot move the case forward in the normal way yet. Competency is a threshold question. Can the defendant understand the proceedings and assist in his defense? Until that report comes in, the court has to slow down. This is not drama for drama's sake. This is the system making sure the defendant is legally capable of being prosecuted.
Your Honor, as the court knows, this matter has been out for competency. We have not yet received the report. I've spoken with the prosecution. I don't believe they have one.
So you do not have a report either?
I don't have a report either. So I will adjourn the competency hearing out. I usually put it out 30 days. Put it out to, what's mine? Is it 26?
Yes. And I
November 26, 2024, 9 a.m. Bond will continue. It should be noted that there were indeed letters sent to the court. They're in the file if you did not get a copy. They were written on napkins. So we did not two-hole punch them. They're in the envelope here.
I was not on the Christmas card mailing list. I did not get a copy. So I would be happy.
We'll be more than happy to share the napkin with you. Don't wipe your mouth with it, please. Thank you.
Thank you.
You're welcome, sir. Court calls case People versus Rebecca Valentine.
Good morning, Your Honor. First, Public Selena Anderson with and on behalf of Ms. Valentine. Ms. Valentine, please state your name.
I'm defending myself, Rebecca Valentine, and I want to enter a guilty plea.
Excuse me?
Your Honor, I spoke with her this morning. She advised me that she wanted to represent herself and did not wish to be represented by the Public Defender's Office.
Is that a correct statement, ma'am?
Yes.
Rebecca Valentine's case immediately raises the stakes. She tells the court she wants to represent herself and enter a guilty plea. Judge Simpson cannot just say, "Fine, go ahead." He has to make sure she understands what she is giving up. Self-representation is legally allowed, but it is risky, especially when the charges are felonies. The court has to explain the nature of the charges, the possible penalties, and the danger of speaking about the facts. And Valentine is already doing the exact thing judges warn defendants not to do, talking openly about the alleged offense. This is where the tension becomes almost unbelievable. She is not hesitating. She is not carefully choosing words. She is pushing forward like she wants to end the case immediately. But the courtroom does not work like a drive-through confession window. Procedure still has to happen, whether she is impatient or not.
All right. Couple things we have to do here then. I do have to advise you that you are before the court on 2 charges of assault on a prison employee. Do you understand the nature of those charges?
Yes, they started it, but I ended it, and I'm guilty, and I want to say I'm guilty.
Ma'am, I'm also going to advise you that you should refrain from saying anything about the offenses, as anything that you say can be used against you in this matter. You also understand that each of these counts is a felony, punishable by up to 5 years incarceration and a $250 fine plus court costs. You understand that?
Yes, I do understand that.
All right. You also understand that there can be great perils in representing yourself in this matter?
Yeah, but I accept that. I don't really think there's that many perils.
You also understand that in doing so, that you would be held to the same standard that an attorney would be held to regarding knowledge of the court rules and knowledge of the proceedings.
That sounds pretty fair.
All right. So your intention is to represent yourself in this matter?
Yes, sir, and plead guilty right now.
You understand, you could please not interrupt me, but if you understand also that if at any time during these proceedings that you wish to be represented by counsel, that you can request that of the court, and the court would appoint counsel to represent you if you could not afford to hire counsel. You understand that, ma'am?
Yes, sir.
And so you wish to proceed today without counsel, is that correct?
Yes.
Public defender is permitted to withdraw as counsel of record, defendant to represent herself.
That ruling is massive. Judge Simpson officially allows the public defender to withdraw, meaning Valentine is now representing herself. This is not a small courtroom formality. From this point forward, she is responsible for understanding court rules, procedure, rights, hearings, and consequences at the same standard expected of an attorney. And here is the wild part. She seems completely confident, even casual about it. The judge warned her about the risks, and she basically accepted them without much concern. Viewers, what do you think? Should a judge allow someone to represent themselves when they clearly want to plead guilty immediately, or should the court push harder to keep counsel involved? Legally, a defendant has the right to self-representation, but moments like this show why judges treat that decision very carefully.
Thank you, Your Honor. Do you need an order?
Pardon?
Do you need an order?
Please.
I'll get that to you right away, sir.
Okay, ma'am, what do you wish to do today?
I would wish to enter a guilty plea.
All right. If you wish to enter a guilty plea, you're going to have to waive your right to a preliminary examination, proceed to circuit court, and enter the guilty plea there.
Okay.
So you wish to waive your right to have a preliminary examination in this matter?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah,
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
yes,
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Ma'am, you understand, and it has not changed from the time of your arraignment to the time that I had just read the charges. You understand that this is, at this point, the circuit court arraignment. You understand that, ma'am?
yes, sir.
The information in this case alleges that on or about November 26, 2022 at Huron Valley Correctional Facility, count one alleges that you did commit an assault on a prison employee, that being a Tracy Maupins. You understand that charge?
Yes, sir. I punched her in the head 3 times.
Excuse me?
Yep, I did it. I punched her in the head.
Well, you understand what you are charged with.
Yep, punching her in the head.
This is the exact kind of moment defense attorneys fear. Judge Simpson is trying to explain the charge, and Valentine keeps blurting out admissions. Not vague admissions, not soft language, direct, factual statements about punching prison employees. The judge even has to keep pulling the hearing back to the legal question, do you understand what you are charged with? Because at this stage, the court is not taking a full guilty plea the way she seems to think. The court is handling arraignment and procedure. Her repeated statements may feel like honesty to her, but legally, they can become damaging statements in the case. Judge Sim's repeated warnings are not decorative, they are protection. He is telling her that anything she says can be used against her, and she keeps saying more anyway. That is courtroom self-representation danger in real time.
It's a felony punishable by up to 5 years incarceration and a $2,500 fine plus court cost. You understand that, ma'am?
Yes, sir.
The information also alleges that on that same date at that same location, that you did commit another offense of assault on a prison employee, that being a Lauren Hales. You understand that charge, ma'am?
Yeah, I punched him in the head 3 times too.
I'm also going to advise you that you should refrain from saying anything about the offenses in this case, because anything you say can and will be used against you. You understand that, ma'am?
Yeah, but I'm already saying I'm guilty, but I understand.
The second offense is also a felony punishable by up to 5 years incarceration and a $2,500 fine plus court costs. You understand that?
Yes, sir.
You also understand that, as I had indicated before, that you do have the right to be represented by counsel. You cannot afford to hire counsel. You would be appointed counsel to represent you. You understand that?
Yes.
All right. This time, ma'am, what I'm going to indicate is that you're standing mute to these charges. That means you're not at this time saying anything about them, and I will be entering a not guilty plea. You understand that?
No, because I want to say I'm guilty. And I thought we found it over to circuit court, so I.
Ma'am, you understand that for the purposes of this arraignment, you're not saying anything about them, meaning that you're standing mute. By law, that means that the court will enter a not guilty plea on your behalf. You will proceed to circuit court, and then you will do what you wish.
Oh, I thought we just switched over to circuit court so I could do that.
Well, we kind of did, but I'm
So I
not
don't
doing the plea. The fact that you don't understand may be why you need an attorney,
I
but
don't need an.
I can't force you to have one, so you're going to proceed on your own. Do you understand what I have just said?
Yep, you're not doing what I said.
Court will indicate the defendant is standing mute to both charges. I'll enter a not guilty plea. Pre-trial in this matter will be set for
November 13th at 1:30 before Judge Conlon.
good luck. November 13th, 2024, 1:30 before Judge Conlon, and I'm sure Judge Conlon will be more than happy to take your guilty plea, ma'am. All right?
Okay.
Bond in this
Have a
matter
good day.
will continue.
And Judge Simpson finally draws the line. Valentine is not getting the instant guilty plea she keeps demanding in this moment. For purposes of the arraignment, she is standing mute, and the court enters not guilty pleas on both assault on prison employee charges. That does not mean the judge is ignoring her wishes. It means the court is preserving the proper process and moving the case to circuit court, where she can later do what she wants procedurally. The key takeaway is clear. Judge Simpson allowed her to represent herself, warned her repeatedly about the risks, explained the felony penalties, and still protected the record by entering not guilty pleas at this stage. Across this script, we saw defendants misunderstand procedure, bond violations collide with personal hardship, competency delay a case, and self-representation turn into legal chaos. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.